just come from the court in relation to Bridgepark. Patricia Grace Guthrie made an application to try to replace us or join herself to the case and technically knock out our legal arguments in favour of her putting in alternative arguments on a judicial review basis, which would have effectively severely damaged our case. The judge found against her that her arguments had no basis in law and that he wasn't able to go forward. She also made an application to adjourn the case on the basis that Brent had served her papers by email and she didn't agree to be served by email. Again, that was knocked out on the basis that on her application to the court, when she made the application to join the case, she put an email address as the contact address, and that then allowed Brent and the court to serve her by email. So again, that was knocked out. Grace also made an argument that she hadn't received documents about the covenant and she had no knowledge about the covenant, and Brent had denied her that information. So that was one of her arguments, and Brent was able to show her that the covenant, that the document that she was arguing that she didn't have, she was never given and Brent never gave her. She herself put a copy of the covenant and in the bundle to the court. So she not only did she have it, she served it. She was the one who served it to the court. So on a number of levels, her argument was knocked out. The conclusion was she also tried to put in a limited company in place of herself, but without understanding that she made the application to the court, so she was the applicant, and the limited company was set up sometime outside of that. Anyway, the point is, she was the litigant in person on behalf of herself, and while she may have been arguing in favour of a CIO, which she said she was going to set up, and a limited company which she had already set up, those entities didn't have standing against the CPR 19 that she was trying to make the order against. She also put a draft order in outlining what she wanted, and each of those points was knocked down as having no basis in law. The court found against her and struck out her case, and Brent was awarded £14,000 in costs against her personally, and she has 28 days to pay. So that's the outcome. So we go forth and we continue to fight the fight. Fortunately, the community is won today, and we still get a chance to fight Brent and Bridgepark to block the sale. The building has not been sold. It is still within our hands. We are winning the case. We've won now one significant hearing in March, a more stronger appeal hearing. We won not won the appeal, we won an application to appeal, and now we've won against Grace trying to knock out the community's case. So on all levels, the community still goes on. We continue to fight. Long be it Bridgepark, and we'll save and fight for the legacy of our community. Well done, Jay. Bye.